Hey everyone, if you're gearing up for your CA Foundation exams, you already know there are some topics you just have to nail. Well, today we're jumping right into one of the big ones, the law of agency. We're going to break down everything you need to know from sections 182 to 238 of the Indian Contract Act.
Think about it from a business angle for a second. This question is a huge deal. How does one single entrepreneur, grow their business? How do they sell stuff in another city or juggle a bunch of projects all at the same time? I mean, you can't be everywhere at once, right? Well, the good news is the law has a really powerful answer for this exact problem.
And here it is, the legal answer. It all comes down to this old Latin saying, which is, and I'm not kidding, the bedrock of all agency law. What it means is simple. He who acts through another acts himself. So legally speaking, whatever your authorized agent does, it's as if you did it. You're on the hook for what they do in your name.
All right, so what does this whole relationship actually look like? Let's kick things off by figuring out who the main players are.
Okay, so the Indian Contract Act, Section 182, lays it out for us. You have the agent, that's the person doing the work, and the principal, the person they're doing it for. It's a simple setup, but it's incredibly powerful. The agent acts for the principal, and in doing so, they create a direct legal connection between the principal and someone else, a third party. Now, here's the real acid test, the one thing you absolutely have to remember. Can the agent lock the principal into a legal contract? If the answer is yes, then you've got yourself an agency.
Okay, so how does this whole agency thing even start? How is the relationship formed? Well, it's not a one-size-fits-all situation. The law actually points to a few different ways this can happen. First up, you've got an express agreement. This is the most straightforward way. We're talking words, either spoken or written down. Like a formal power of attorney. Then there's implied agreement. This is where you look at how people are acting, the situation, their relationship. The law can also step in and create one by operation of law. A classic example is how every partner in a firm is automatically an agent for that firm. And then there's this really cool one, ratification. This is where someone does something on your behalf without your permission, but you approve it later. It's like creating the agency backwards in time. Okay, pens out, highlighters ready, because this next one is a huge deal, especially for your exams. We're talking about a special type of implied agency called agency by estoppel. This is all about what happens when the principal's own behavior makes a third party think, hey, that person is their agent, even if there was no official agreement. Let's walk through a classic example to make this super clear. You've got Piyal, the principal. For months, he lets his guy Sunil go to Prasad's shop and buy stuff on credit. And every single time, Piyal pays the bill, no questions asked. So what does Prasad think? Naturally, he thinks Sunil is Piyal's agent. Because of Piyal's consistent actions, the law steps in and says, Piyal, you are now estopped or blocked from turning around and saying Sunil wasn't your agent. The bottom line? Piyal has to pay up. His actions created the agency, whether he meant to or not.
All right, let's move on to something that, honestly, trips a lot of students up. So what happens when an agent gets overwhelmed and needs a helping hand? This is where we get into the super important difference between a subagent and a substituted agent. Trust me, getting this straight is crucial.
So there's this legal principle, another Latin one, delegatus non potest delegare. It just means a delegate can't delegate further. Think about it. The principal trusts you, the agent, to do a job, so you can't just pass it off to someone else. It's all about that personal trust. But of course, in the real world of business, things aren't always so simple. So there's some really important exceptions.
This chart really spells out the difference. So let's break it down. A subagent, they work for the agent. The principal has no direct link to them. This means the original agent is on the hook for whatever the subagent does. Now, a substituted agent is a completely different story. The agent finds them, but they work directly for the principal. They have a direct link. Once the original agent has carefully chosen that substituted agent, their job is pretty much done. See the difference? It's all about who they work for and who's responsible.
Okay, so we've created the agency. Now what? What are the rules of the game? Well, both the agent and the principal have a whole set of duties they owe each other and rights they can claim.
Let's start with the agent's duties. This is huge. An agent has what's called a fiduciary duty to their principal. That's a fancy way of saying they have to act with the utmost good faith and always put the principal's interests first. That means following instructions, using reasonable skill, doing a good job, and of course, keeping track of the money with proper accounts. And a couple of big no-nos. They can't secretly profit from the deal. And they can't start dealing on their own behalf without the principal being totally okay with it.
But hey, it's not all about what the agent has to do. It's a two-way street. The agent has rights too. First and foremost, the right to get paid, the remuneration. They also have the right to get their money back for any legitimate expenses. There's also the right of lien, which is interesting. It means they can actually hold on to the principal's property or goods until their dues are cleared. And importantly, if they get into trouble for doing something lawful for the principal, they have a right to be indemnified, basically to be covered for their losses.
All right, so the agent is the middleman, right? They connect the principal with other people. But that leads to a really important question. What happens if something goes wrong? Can the agent themselves be held personally liable for the deals they make?
Well, the general rule, according to Section 230, is a big, clear no. For the most part, an agent is not personally liable. Just think of the agent as a kind of shield or a bridge. As long as they're acting within their given authority and everyone knows who the principal is, the final contract is just between the principal and the third party. The agent can just walk away, totally protected.
But, and this is a huge but, there are exceptions, and you absolutely have to know these for your exams. The agent's shield disappears, and they are personally liable in a few cases. For example, if the principal lives abroad, or if the agent doesn't even mention who the principal is, or if the principal can't be sued, like if they're a minor, and the most obvious one, if the agent is just pretending to have authority they don't actually have. In all those cases, yeah, they're definitely on the hook.
So, like all good things, agency relationships have to come to an end. They don't last forever. So let's talk about the final chapter, termination.
Basically, termination can happen in two main ways. The first is by the actions of the people involved. The principal can just say, "You're fired," and revoke their authority. Or the agent can say, "I quit," and renounce the business. Simple enough. The second way is by operation of law. This is when something happens that automatically ends the relationship, like the job is finished. Or, more seriously, if either the principal or the agent dies or becomes legally insane. The principal going bankrupt also ends it right there.
So, we've said a principal can just revoke the agency. But here's a final thought to chew on. What happens when the agent has their own skin in the game? What if they have a personal financial interest in the business itself? This is called an agency coupled with interest, and it brings up a massive question. Can that kind of agency just be revoked on a whim? The answer lies in Section 202, and trust me, it's a super important exception to the rule that you'll definitely want to check out yourself.